Hi, happy St. David's Day and welcome to this latest immigration update video. Today I want to talk about a new case that's just out from the upper tribunal looking at the statutory Article 8 considerations that were brought into the 2002 Act by the 2014 Immigration Act. So the case is called Dubé, and in brackets it says sections 117A to 117D, and it's 2015 UK-UT 90, and it came out on the 24th of February this year. And it's a decision of Upper Tribunal Judge Story sitting with Mr. Justice Nicol. And what Dr. Story does there, it's an allowed appeal, and it's a Secretary of State's challenge, and he looks at the failure to consider the section 117B criteria in this determination. And he says judges are required to take into account the considerations set out in 117A to 117D. They're not an a la carte menu. Judges are duty bound to have regard to the whole of the specified requirements. Now, you'll know that the actual Act says these requirements are binding on a court or tribunal when considering Article 8. But what Dr. Story notes, and it's in the head note, is that it might be good administration for the Secretary of State to start to have consideration to these statutory factors. Now, while expressed in mandatory terms, these are not exhaustive considerations. So 117A to 117D are not exhaustive of Article 8, because notice the phrase must have regard in particular to these considerations. And these considerations apply, 117B applies to all cases. Obviously, additionally, 117C applies to foreign criminal cases, in addition to 117B. And interestingly, they'd say 117A to 117D are not a radical departure or override from previous Article 8 case law, and they don't disturb the need for judges to go through the Rasgar steps. And effectively what he says is 117A to 117D are effectively an elaboration of question 5 of Rasgar, so about proportionality and justifiability. So when a judge is looking at proportionality, these considerations will inform his balance. Now, notice what's also said is that it's not an error of law for a judge not to consider these factors if he or she has applied the right test. What matters is substance, not form. So if it would have made no material difference, it's not an error of law for a judge to have failed to consider it. But clearly judges should consider it, and there are cases where it will make a material difference. So what's the practical ramifications for practitioners? I think the thing to bear in mind is to deal with it in your grounds of appeal, in your representations, in your skeleton arguments. Some of them are interesting because the ability to speak English, there's no specified test for English there, and notice the criminality guidance for Article 8 from the Home Office says that. Also in the financial independence section, that doesn't mean 18,600, again there's not a specified amount. 117B6 has proved very helpful in cases with British citizen children. So these factors actually can play to an applicant's advantage. Also in foreign criminal cases, 117C is probably more generous than the immigration rules. So plead the statutory guidance, make sure you deal with it. When you're drafting grounds of appeal, has a judge considered it? If he hasn't, would it have made a material difference? If a judge has allowed an appeal and failed to consider the statutory considerations, you might want to put in a response citing Dubé, saying, well, it wouldn't have made a difference at all. Importantly, you need to deal with it at the appeal stage to make sure a judge does deal with it and doesn't leave a determination open to attack. I haven't gone through the facts and the rest of the determination in Dubé, but it's worth having a look, especially what Dr. Story says about the ratio of EB Kosovo and how that might be affected by the statutory considerations. So have a look at this judgment, important guidance on the new statutory considerations for Article 8. I hope that's helpful.